Incidentally, practical or logistical difficulties in producing an account will not prevent an account being ordered. And in terms of time limits, there's no statutory time limit, but if there is a significant delay, that may be a reason why the court would refuse to exercise its discretion. Ali and Taj, though, was a case where an account was ordered after 11 years. And so there have to be fairly significant delays before you get into that territory. The sorts of cases where delay has led to an account being refused range from between 7 and 35 years or so, but ultimately it depends on all the circumstances. And just to underline the fact that these are pretty serious orders, notwithstanding the fact that they come out of the probate registry and non-contentious proceedings, if an executor doesn't comply, then of course enforcement is by way of a committal application. What should the account contain? Well, it has to contain what's called a true and perfect description and valuation of all the estate. But that, of course, has to be given against the backdrop where the purpose of this application is to enable a beneficiary to know what's going on with the estate. The court has a discretion as to what to accept. Now, one question that often crops up in these types of applications is what cost information has to be given. It's not unusual for a beneficiary to take issue with the costs that have been incurred by an executor, perhaps through, or usually through a firm of solicitors, and to argue that they're unreasonable in some way. Now, what cost information has to be put into an account in those circumstances? Well, this was a question that was considered by His Honour Judge Matthews in the 2018 decision, Muscle and Patience. And the judge held that for the purpose of an account, an executor need only show that, firstly, the sum concerned was indeed spent, and secondly, that it was spent in the fair execution of the estate. So the first part of that can normally be demonstrated by a document such as a receipt showing payment, and the latter point is normally satisfied by an invoice referring to the executor and the estate and to some service that's been provided. It's not necessary, or the judge took the view it wasn't necessary for those documents to disclose, for example, the number of hours worked or the hourly rate, so as to arrive at the total charge, or indeed to give a detailed narrative such as you'd find on assessment procedure, on an assessment. Now, contrast that application with an application for pre-action disclosure, where the main difference is that it's governed by the CPR, and you really need to be able to show a prima facie case in order to obtain disclosure. Remember, the first part of the test under CPR 3116 is the need to show that it's likely that the respondent and applicant are likely to be involved in subsequent proceedings. There are other considerations too. And of course, the cost rules are different. So where you have pre-action disclosure, the general rule is that the court will order the person, the general rule is that the court will order the applicant to pay the respondent's costs, and to deviate from that default position, you need to show, again, either unreasonable behaviour or a failure to comply with pre-action protocols. So, as I say, usually the account is the first port of call when a beneficiary is looking for information as to the assets and how they've been dealt with. But once you get into the realm of misfeasance and have established some sort of prima facie case, and perhaps want to look at what's happened to assets before the estate started to be administered, assets that might have been transferred out before the date of death, then you're probably getting into the range of pre-action disclosure. The second application I'm going to talk about, which is a pretty essential one, is a BEDO application. Now, I'm sure most people know, but I'll just briefly summarise what that is. It is an application for directions as to whether to bring or defend legal proceedings, whether or not personal representative or trustee should do either of those things. Of course, if PRs, without the sanction of the court, bring legal proceedings against third parties, they can be liable for the costs if ultimately those proceedings fail in one way or another. And their indemnity from the estate may not be available if they shouldn't have brought the proceedings or defended them in the first place. And so in order to obtain protection against that happening, before defending or prosecuting many types of claim, it's well worth considering whether or not to make an application for a Beddoe order. Of course, one case where an application isn't needed is when all the beneficiaries are known, of full age, and able to decide about what to do in respect of the claim, and indeed agree with each other. The difficulties arise when one or more of those conditions isn't satisfied. So you may have, for example, beneficiaries that simply don't reach agreement, or you don't know who all the beneficiaries are, or there may be beneficiaries who don't have capacity to give a decision. And another consideration, of course, is you may have beneficiaries that want to bring a claim and agree on it, but the trust fund may not be sufficient to indemnify the trustee if the claim doesn't succeed. All of those cases, as I say, are ones where a Beddoe application should be considered. In terms of the procedure, they are, of course, brought in at separate proceedings to the main action because of the nature of the information that you disclose within them. The guidance on how to make an application and the evidence you need is set out in CPR 64 and Practice Direction B. And in particular, the evidence that's needed is summarised in that practice direction. And you need evidence on the merits from an appropriately qualified lawyer. You need an estimate of the value or other significance to the trust estate of the issues in the proceedings. You need information about the costs, both to the estate and to the other side, and the potential liability that the estate can be exposed to. And another important consideration are the extent to which there's been consultation with beneficiaries. And the evidence has to explain that. Now, one point that is well worth bearing in mind is that you should try and use the same lawyer who's written the advice on merits to deal with the application hearing, if at all possible. That's something that's specifically stated in the practice direction, but that's sometimes overlooked. So, broadly speaking, how do courts approach a Beddoe application? Well, courts make orders ultimately when they're satisfied that in the circumstances of the case, as they are known at the time, the usual indemnity as the estate will apply, and the exception that the costs have not been properly incurred will not. And that necessarily involves consideration of all of those matters that need to be in evidence, like the merits, the benefit and risks to the estate, the views of beneficiaries, and anything else that may be relevant. But it's also important to consider what type of claim it is, because certain types of claims almost always necessitate Beddoe applications, and others rarely, if ever, do. And there are three types of claim that were summarised in a case called Alsop, Wilkinson and Neary, a 1996 decision. And the first type is a trust dispute, which can itself be friendly or hostile. So a friendly dispute may be an issue about the construction of a will. A hostile one might be a claim by one beneficiary to the share of another beneficiary under the trust. You then have beneficiary disputes, which are generally disputes where a beneficiary sues a trustee for breach of trust. And then the third type of dispute are third-party disputes that have nothing to do with the internal workings of the trust, but instead have something to do with the relations between the trust and a third party. Now, one example might be a boundary dispute, for example, that involves the estate, or maybe a case where the trust is looking to recover assets for the trust from third parties that are not beneficiaries. But it's important to consider which type of dispute you're dealing with. In terms of third-party disputes or true third-party disputes, these are the typical cases where if the beneficiaries can't agree what to do, the court will direct the trustees either to deal with the litigation or not. Those types of applications are actually the more straightforward end of these cases. There are then beneficiary disputes, where the court is usually unable to predict in advance what the outcome will be, because it often involves a finding as to whether or not the trustee personal representative has breached a duty. And in such cases, costs usually follow the event and a better order won't be made. You then come to trust disputes, such like friendly disputes over the construction of a will. Well, in those, the court's likely to make a better order if there's an issue to be resolved in construction and the beneficiaries willing to agree about what to do, at least unless it's so obvious that a construction application should be made that it's a waste of money to apply for one. The more difficult cases are perhaps hostile trust disputes. Now, the usual position in those is that if rival claimants to the trust fund want to have a fight about who owns what, the trustee should remain neutral and allow them to fight it out. But where difficulties arise are when it's unclear whether the trust is whether the dispute is properly a third-party dispute or a hostile trust dispute. Now, a true third-party dispute, for example, may be one where the trust is recovering property from someone that's unconnected to the beneficiaries. The hybrid situation happens when perhaps it's one of the beneficiaries that's taken assets out of the trust or out of the estate prior to the death of the testator. As I say, those cases are more complicated, and in them the court invariably has a much more detailed look at the risk of injustice if the estate has to foot the bill for proceedings that ultimately fail. There are, though, two recent cases that look at these issues. One is Dillon and Dillon. Now, that's a case where a claimant, who is the executor of a will, sought permission to bring a claim to recover assets from his brother, who was also an executor and beneficiary. And part of the proposed claim was on the basis that about £500,000 had been transferred out of the estate as a result of undue influence and forgery. And perhaps you might think surprisingly, the court was in fact prepared to grant a better order on that in that claim, but it imposed certain safeguards. It only gave permission to take proceedings to a certain stage, and made any order subject to what the trial judge ultimately decides to order to. I mean, one important thing in Dillon and Dillon, though, was that the merits of the claim were considered to be strong. Contrast that with Lyons and Wilcox, again, a decision of His Honour Judge Matthews. And in that case, the claimant administrator of the estate wanted to bring a claim that concerned an issue as to whether or not a house, which was a large part of the estate, had been transferred out as a result of undue influence. And that was a claim against another beneficiary. And in that case, the judge thought there was a risk of too much injustice if the claim failed. And he declined to grant permission for the executor to bring the claim, and that left the beneficiary effectively to pursue a derivative action. And there's an interesting, I think, approach to the way that His Honour Judge Matthews looks at these disputes, and that was to say, at first blush, the duty of the claim as administrator is not to take the risk of proceedings and to remain neutral. He asked himself whether any particular circumstances of the case that altered that provisional view, and having considered a whole range of factors, decided that there wasn't anything. But as I say, those cases really need to be looked at in detail. So in summary, what are the key points about BEDO applications? First of all, you don't need them if all the beneficiaries are full age and can agree on what should happen. And of course, there's a sufficient trust fund to indemnify the trustee. Otherwise, you need to give careful consideration to them. And in many cases, they are essential when a trustee or a PR is embarking upon litigation. In particular, where there are true third party, or where it's true third party litigation and the beneficiaries don't agree on what should happen. And one final point of warning: the protection afforded by a BEDO order is only effective if full disclosure has been given at the outset, and if it isn't, that can undermine any order that's made and its effectiveness. So with that, I will hand back to Faye. Stop that screen share. And I think that should be sufficient.
Okay, thank you very much, Nathan. So I am going to move straight on to summary judgment applications. And I think it's fair to say at the outset that summary judgment applications are not particularly common, well, not common at all within the world of probate administration of estates. And that contrasts somewhat with other areas of civil litigation. Certainly I remember from my days when I started at the bar and PI, when we'd have them all the time. And it may well be that in other aspects of civil litigation that have a more commercial aspect to them, that they are more common. But for some reason, in probate proceedings, we don't see them very often. And I wonder whether that has a lot to do with the fact that there's much more of a supervisory jurisdiction that's exercised by the court. So it's not really matters of adversarial litigation and tactics that we're dealing with. So I wonder if the balance of those factors is one of those reasons. But it's still an application that you need to know about. In my view, you may disagree with that. And I really say that for two key reasons. The first is that there's no provision to obtain a default judgment in a probate claim. And that differs somewhat to other areas of civil litigation, where if a defendant fails to file an acknowledgement of service and a defence, and then the time periods have expired, the claimant can then make an application for default judgment. But 5710 in the CPR expressly excludes the right to do that. So prima facie, without the ability to do that, then a claim can continue. And it may well be that you, as acting for an executor, for example, are faced with a particularly weak or unmeritorious claim. And as we know, this type of litigation is notoriously very expensive. And your clients will be saying to you, this claim is completely unmeritorious, and you've told me that my chances of successfully defending it or winning it are pretty high. So why do we have to wait the year or so to go through a trial timetable, and maybe even longer now because of the listing issues that we're all going to be facing because of the public health crisis? And in those circumstances, when you do have a particularly weak case on the other side, it's always right to pause and think in the early stages of litigation whether a summary judgment application is appropriate for the set of circumstances. Now, they won't always be, but certainly I think maybe for tactical reasons as well, as in addition to cost-saving measures, it's worthwhile thinking about. Now, before I move on to summary judgment, I'm just going to draw your attention to one provision in Part 57 that some of you may be aware of, so I apologise if you are, but for those of you who aren't, it's certainly something that's useful to know about. And it arises sometimes from examples where you have particularly litigants in person who will enter a caveat, then you try and warn them off, and then they appear to that warning. And they say something along the lines of this, which is very broad brush and generic. I'm going to provide you with some evidence that the will, it was incorrectly executed and therefore invalid. But they don't give you or your executors or your clients any substantive details to enable you to enter into proper discussions with them about how you might compromise or move forward in that litigation or proposed litigation. But because there's the caveat in place, there will come a point when the executors have to issue a claim to prove that will. Now, you may find yourself in a situation where, notwithstanding an aggrieved family member or third party who has been disinherited from the will, notwithstanding that they have appeared to a warning and said that they feel that the will is not validly executed, for example, after issuing your probate claim, ultimately, they may not bother to take it any further. And you find that happens quite a lot, or certainly I do. Whereas once the litigation starts, I actually think, hang on a second, this isn't something that I want to be involved in. So you may find yourself in a position where you've issued your claim to prove your will, but the other side actually fails to file an acknowledgement of service and a defence. And then the time limits for those documents have passed. Now, the time limits are set out in 57.4, and they are slightly longer than normal Part 7 proceedings. So it's worthwhile just giving Part 57 a read if you're not particularly familiar with it. But if the defendant doesn't file the acknowledgement of service and the defence, and those time limits, the 28 days from service of the particular claim has passed, what you then must do is file written evidence of service of the claim form and particulars of claim, so that's not going to trouble you too much. And then you can ask the court to give directions for the claim to be considered on written evidence. And that is probably about as close as you can get to a default judgment application or a request for one. And it will involve you and your clients spending some time on getting the requisite evidence in terms of proving the will so that the testator was free from influence, they had capacity, knew and approved of the contents. But you can deal with that pretty simply in some witness statements, which you should really have already available to you by this point anyway. And the court will then sometimes deal with it on paper. Sometimes it will ask for a hearing. It depends which court it's being dealt with. But the consequence of that is that you short circuit going through standard directions that you would have in a Part 7 trial. So just bear in mind, if you find yourself in that position where you think, gosh, we just want to draw an end to this, but we're faced with another party that just isn't playing ball but isn't bothered about the claim, then you can certainly consider Part 57.10. Now, the difference with summary judgment usually is that you've issued your claim, but actually there is a response from the defendant. But the response isn't particularly good as far as you're concerned. Now, unlike default judgments, Part 57 doesn't exclude the right of a claimant or a defendant to seek a summary judgment in a probate claim. And so there is, in an appropriate case, the provision under 24.2 to make an application for summary judgment. And the application you'd be thinking about making is set out there, which is one to pronounce for or against the will by way of a summary judgment. And you approach that very much in the same way that you would with summary judgment applications for those of you who deal with other aspects of civil litigation, with a Part 23 application notice and your witness statement to accompany that. Now, the test for summary judgment is really well known, so I do apologise for if some of you are so familiar with it, you're saying, why on earth is she taking us through this? But some of you may not be, because as I say, those who do specialise in probate work may not come across this type of application very often. So it is important to understand the remit of it, because if they are hotly contested and fought, it can end up being an expensive application if you lose. And of course, if you lose, then the cost will usually follow the event. So you do have to think at an early stage whether it's right, whether it's worth the cost risk. And there will be those cases, I think, where it is worth taking that risk, especially if you've got a big estate and your client really wants to fight it tooth and nail. But the test falls into two parts. And the first part is that there has to be no real prospect of succeeding or defending the claim. And I emphasize real there because that's where all the case law and the jurisprudence comes from. So these are the types of questions that when a court is addressing this as part of its judgment, that it will ask itself. If the respondent to an application can show that there is some chance of success, albeit a small one, then that will usually defeat an application. Now, at this stage, the court isn't deciding the claim on the balance of probabilities. The hurdle at this stage is much lower than that. So if there is some chance, then it may well not be an appropriate application to make. But it has to be more than merely arguable. So somebody may say, well, I think that will is invalid because my sister procured it by unduly influencing the testatrix. Well, that is an arguable case, but is there some prima facie evidence to that? Something that puts a bit of flesh on the skeleton of an undue influence claim. And it has to be something that's not fanciful, false, or imaginary. And really, there has to be an absence of reality to it. Now, those cases are less common, but they are out there and they do exist. And for you as a claimant and making an application, it will be for you to produce some credible evidence in support of it. So at that stage, you'll be thinking about producing your witness statements from the solicitor that assisted in drafting the will, or the attesting witnesses, providing some early disclosure, which you should have done by this point anyway, of the will file. That's going to be providing to the court credible prima facie evidence in support of the application. Then what happens is the burden, or the evidential burden, is then passed over to the respondent to come up with something to show that there are some real prospects. And it may well be that they say that there's a lack of testamentary capacity, but that's not going to be enough. There has to be something to support that, certainly at that stage. But one thing I will emphasize here is that the court, and this is a very well-known saying in these types of cases, won't conduct a mini trial. So it's not for an interim case management judge at this stage to be looking at two witness statements and saying, well, I believe that witness over that one, or that seems more likely to me than that one. Where we've got parties putting different versions of events, different facts, and if one party's set of facts are proven, it will lead to one outcome. Conversely, if the other party's facts are proven, it will lead to a different outcome. There you've got disputes of fact, and they need to be resolved by a trial judge. But there may be those cases where, even at its highest, the claim, even if they make out their factual basis that they rely on, that actually doesn't succeed, that doesn't win the claim or defend the claim for them. And those are the types of case where if you think your analysis early on is, well, even at their best case can't succeed, then those are the kind of cases I think where you want to be thinking about summary judgment applications. And then the second stage that we move on to is that there has to be no compelling reason why the matter should proceed to trial. In other areas of civil litigation, the second stage is very often ignored. I certainly found when I practice in other areas. But in probate litigation, it is more important because of the supervisory jurisdiction that the court exercises. Because the court may say, well, I agree that there is no real prospect of succeeding, but I'm still not satisfied that this aspect of the will is proven. Then that may well be a compelling reason why it should go to trial. And so that's why at this stage, you need to have your evidence ready that deals with those three factors that are at the bottom of the slide. And that's why you will need your witness statements from any solicitors that drafted the will. And if you have any other evidence available to you that you may well have obtained by this stage anyway, because these claims are very often front-loaded, I would very often exhibit that all to the application notice anyway, if it's there and available. And if a court is satisfied that the will is valid and that it can prove it in solemn form, then the second stage of the test is satisfied. So the big question is, well, when is it going to be appropriate? And I can't give you a broad principle to apply to that, because in a very lawyerly answer, it depends on the facts of the case, and it really, really does. But there are certainly some cases that I think will help you or guide you when you are thinking about this. And you'll probably all be aware of the Templeman case. When Nathan, Sarah and I did the recent case law update, Sarah dealt with the substantive claim in detail. But before the claim was heard, there was an application for a summary judgment made by the executors of the will that ultimately was proven. I'm sure many of you have read the latter judgment, and you'll know from reading it that there were a number of disputes of fact. There was evidence that was heard from Professor Jacobi, I believe, as a factual witness. There were different experts' reports that gave different views. When I read the judgment, I thought, I can't believe they've made this application, because it was so obvious to me anyway, although that's easy to say, that there were disputes of fact and that it was going to be a real struggle. But the master said there that because of those disputes of fact, that there were triable issues that require determination by a judge after they've assessed all the evidence and heard all those witnesses. So if you have that kind of case, and very often they are those kind of cases, then an application may well not be appropriate. But there are two cases that I thought of that I think do shed some useful light on this. Now, many of you will be aware of the Bashait and Patel case that deals with a 1975 Act claim, and that was the one where I think it was Chief Master Marsh allowed the wife to bring her 75 Act claim, I think it was 26 years out of time. Now, whenever I discuss that case with people, I always say, go and read the first judgment that was dealt with by Chief Master Marsh, that deals with a strikeout application and an application for a summary judgment. And that reference there is to that judgment, because what the wife did before she brought her 75 Act claim was to bring various claims alleging that there were the property that was the main asset of the estate was held on resulting trust, on constructive trust for her. She also made one of the strands of the claim was to the statutory legacy, but by that time it was limitation barred. And the kids in the claim brought this application to strike it out and for summary judgment, because what they said was, even if the wife's facts are made out, that doesn't lead as a matter of law to the trust that she is now claiming. And the judge agreed with them on that. And the judge struck the claim out. Now, I recognise that that's not a truly contentious probate case, but it's useful because very often you'll get those kind of considerations in your cases. But what it shows are two things, is that you can get summary judgment on cases of this nature with the right set of facts. And also, be mindful of Part 8 claims, and this is where I think it's going to be useful for Inheritance Act claims, because with your Part 8 claim, we all know that it's supposed to be front-loaded. So when you serve your claim form, you're supposed to have, although it very doesn't often happen, but you're supposed to have all your witness statements ready. Now, it's difficult because of the time limit. And what Chief Master Marsh says is that when you get the Part 8 claim, you are entitled to accept that that is all the evidence they're going to rely on. It's not for the claimant to say, well, when we go to a CMC, I'm going to be asking for provision for further witness statements, further disclosure, because that should already be there. And so that's why I think that there may be a greater opportunity to use summary judgments in hopeless 1975 Act claims. Because when you get that claim, you should be entitled to accept that that's the totality of the evidence you're going to get. And if that witness statement, when you read it, think, well, even if they're right, so what? You're not going to succeed on that, which very, I very often find myself coming to that view on a lot of these claims. But if you find that, you may think, well, actually, a summary judgment application may well be worth considering. And that's why I've referenced that case there of Shapton and Saviour, because it was recently reported in the press as an Inheritance Act claim where the estate was left to the wife, I believe, who was pretty impecunious, was also suffering from health effects herself. And the adult children brought their own 75 Act claim, but they were pecunious, they had their own jobs, they were self-sufficient. Yes, they have credit card debts, but don't most people nowadays? And the master said that the claim was absolutely hopeless. And when I read that, I just thought, had they thought about a summary judgment application? I don't know whether they did, but I certainly would have been thinking about that if on the other side I'd come to the same view that the claim was absolutely hopeless. So if anyone has got a case like that and you want to give a summary judgment application a go, then by all means, get in touch. So moving on to Benjamin orders. Now, these aren't as common, but for those of you that are dealing with the administration of estates, definitely something to be mindful of. And the first question is, well, what is a Benjamin order? To which I'm going to find the answer when I turn my notes over. And I'm going to give you just a sort of brief factual scenario. Say you have a young gentleman who has gone on holiday and his employers say, Joe, we need you to come back. We need you to start work again because now the pandemic is over. You can start your job in the local bar. And so he gets a train back and then he vanishes and he's never to be seen again. Nobody knows whether he just thought, no, I don't want to go and work in my local bar again. I want to go to Australia and start a new life. Or it could be, tragically, that he had some accident and nobody knows about it. But then very sadly, the next year, his father passes away, and his father had a very significant estate, leaving all of his estate to his son. What do the executors do? Because they don't know what's happened to the son. And that's where you want to be thinking about a Benjamin order. They very often crop up with missing persons, or where you've got a gift, for example, with a class of beneficiaries, not a discretionary class, but just an outright gift to a class of beneficiaries. And you can't find some of them, despite your attempts to do so. Or you can't, for example, locate a creditor, and you know that there is an existence of a debt. So they're typically used or applied for where the personal representatives are unsure about who is entitled and how to distribute the estate because of some uncertainty about the right set of facts. Now, why do you need to know about it? Well, what the order allows a court to do is to assume a set of facts. So taking our example, the evidence may well be that Joe met a lady on a train and they ran off to Australia and they got married and something's cropped up on Facebook, but they're not entirely sure. They've had to do a bit of digging. And the judge may well accept that evidence and say, well, I'm going to assume for present purposes that Joe did run off to Australia rather than Joe has actually died. And so it allows the court to assume a set of facts and then give directions to the personal representatives about how to distribute in light of those assumed set of facts. And you need to know about it because, well, what if the personal representatives in our example thought, well, Joe has very tragically passed away, and so we've given it to the individual who is entitled under intestacy or the substitute beneficiary in the will. Joe comes back 3 years later and says, where's my £1 million inheritance? The personal representatives may find themselves in some difficulty because of that. So they may want to have the assurance from a court that they are doing the right thing. And that's important, because if they do distribute, arguably not in good faith, because then put on notice that something might not be right, then they are potentially personally liable if it turns out that they've done that incorrectly. So that's why it's so important. But the other thing I want to emphasize is, even if a court goes on to make a Benjamin order, say Joe then does come back 3 years later, and the money has been given to the wife under intestacy, it's not going to stop Joe from seeking to trace and reclaim that money back from mum. So there is still a remedy. It's just you're using this order to protect your personal representatives. So when will the court make a Benjamin order? And typically it falls into sort of these three categories. So you will have provided your evidence from your personal representatives of what the situation is and what difficulty they are facing, what steps they have taken to try and ascertain the true position. And the expectation about the investigations you'll have to undertake are going to be quite extensive. You're going to have to instruct inquiry agents, make use of social media, anything that at the personal representative's disposal. And so you presented that all. And what a judge will often look at is whether the proposed distribution reflects the practical probabilities of what has happened. So based on what the evidence is this probably what's happened? Yes, it is. We'll distribute on that basis. Conversely, it may be where there is a practical impossibility of proof of the facts or events in question. So it may well be that with Joe, there is just absolutely nothing that you can find. And so we cannot ascertain at all what has happened. Very often it falls into the third one, though, where you've taken every reasonable step to trace the individuals in question, and it's improbable that any such individual would ever establish a claim. The reality is they're all saying the same thing. It's just that courts have phrased it in a slightly different way. But for your purposes, if you are faced with the need to do something like this, you need to be thinking about an application under Part 64 of the CPR. And that is, of course, going to be under the Part 8 regime. So as I say, you have to front load everything. You'll have to address in that evidence what alternatives you've thought about, because there are alternatives. It follows that any application to court incurs costs for the estate. Those costs, unless an executor has acted unreasonably and unreasonably incurred costs, unless it falls into that category, then the cost will come from the estate for the personal representatives. But always have a think about insurance. Usually that's only where there's modest sums involved. And there's always a possibility of an indemnity from the beneficiaries as well. But an indemnity is only as good as the pockets, or as deep as the pockets of the beneficiary. And it may well be that they're good for the money then, but what about in 3 years' time when Joe comes back? And of course, in terms of tracing, there's no limitation period there. So it can be something that catches people out a number of years down the line. So you'll need to address what other alternatives you have looked at. Now, you may be saying, well, what about the Presumption of Death Act? If you think, well, is Joe dead and I need a declaration on that? Well, of course, that has its place, and there will be some times where you do need a declaration, because a Benjamin order does not give you a declaration about when somebody dies, and that's what the 2013 Act does, because the court tries as best as it can to make a factual finding about when the individual passed away. So Benjamin orders don't do that. They are not making findings of fact. They are merely assuming facts for the purposes of guiding the personal representatives. But you may need a declaration, for example, when it comes to life insurance payments. That's very often why people proceed down that route. The other point is that Benjamin orders, the jurisdiction is much, much wider. So in the 2013 Act, declarations can be made about when somebody passes away, but that's where it ends. A Benjamin order, a court can assume that Joe passed away without having any children. They can also assume that Joe passed away without being married. So it can take it one step further, which is important when we're thinking about who is going to inherit under the rules of intestacy. Also, Benjamin orders, as I say, cover things beyond missing individuals. There may well be an issue with the creditor that just cannot be found for whatever reason or cannot be ascertained. So the Benjamin order has a much broader scope than the 2013 Act. But really, if there's one sort of learning point that you need to take from this, is that a Benjamin order is really to break the impasse that may be faced in the administration and distribution of an estate because of some uncertainty about to whom the estate should be distributed. The final matter I'm going to raise with you is about the put up or shut up order, which was not my phrase, it's that coined by the Court of Appeal in the case of Sherman. Now, some of you may know about these orders, but they are pretty rare, I would say, although I think they can be very usefully used in the litigation in which we're involved in. But essentially, it assists a personal representative, for example, where they have already obtained a grant of probate. So the will is effectively taken as being proven. But then somebody comes along and says, well, I dispute that will, and I think that the testator lacked testamentary capacity when they made it. But as far as you're concerned as PR, you've already got your proven will. But then you've got to think about Section 27 of the 1925 Act, because a PR is protected in distribution as long as they do it in good faith. Is a PR distributing under a will in good faith if they know that there is an allegation that, notwithstanding the grant of probate, it is invalid for want of testamentary capacity? Most PRs would feel uncomfortable about that, and certainly as those advising those PRs, you would feel uncomfortable advising them about proceeding. But the problem is the person who's challenging it just won't do anything about it. And so in those situations, it can lead to this very frustrating situation where there is a question over the validity, but the person won't put up or shut up about it. So the Court of Appeal have said in Sherman a number of years ago that where that happens, it's perfectly proper for an executor to seek a direction from the court that the estate can be distributed in accordance with a will or a codicil unless the person challenging it brings those proceedings within, say, 28 days. So it's almost like an unless order in a way. And that was applied in the case of Cobden Ramsey, where the will left the residuary estate to son and daughter in equal shares. It was a fairly modest estate, I think only about 350 or odd. But then subsequent to the will, the testator had executed a codicil which gave 2 pecuniary legacies to third parties. The son alleged that the codicil was invalid because of want of testamentary capacity. But by that time, the executor, who I believe was not beneficially interested in the estate, had obtained a grant of probate. And despite a number of years toing and froing with this son about what he was going to do, he refused to bring an application or bring proceedings to revoke the grant of probate and challenge the codicil. So what the PR was forced to do was to seek an order from the court permitting him to distribute the estate in accordance with that will codicil, unless the son brought the probate proceedings within the 28 days. So you can see that that's quite a useful tool to have in your bank of applications if you find yourself in that impasse that's created by, one, uncertainty about who should be inherit or to whom it should be distributed, and 2, because there is a proposed challenge to the will but the person won't actually follow through with it. So you can use the remit of a Benjamin order to break that impasse for the personal representatives. And there we go. That is the end of my section on the seminar on the probate applications. I hope you found that useful. This is recorded, although I forgot to record for the first 3 minutes of Nathan's talk, so sorry, Nathan. But it does go up on the website, so if you do want to pass it to your colleagues, by all means. I always email afterwards and send out the slides as well. So of course, feel free to disseminate those amongst your friends and colleagues if they so wish. And as I say, if you've enjoyed the seminar, I personally would really appreciate it if you can always mention us on Twitter or certainly LinkedIn. And if you have any topics that you would find useful for any of us to speak on that fall within probate and property or property and affairs court of protection, then do feel free to get in touch and recommend those. But it just falls to me to thank you again for attending this seminar. And I hope you will all now go and enjoy that lovely gin and tonic in the gorgeous weather, because that's certainly what I'm going to be doing. Thank you very much.